Okay, so call to order. Board members present. We have Gershom.
Here.
Are you here? Larry?
I'm here.
Here.
Michael, not here yet. Mary here. Olivia? No, Olivia. Okay, so 3 board members are here. Okay, take it away, Josh.
All right. Just for the record, I want to introduce the guests. My name is Josh Ripp. I'm the head of school. Kimberly, would you mind introducing yourself?
I'm Kimberly Rodriguez, and I'm an attorney with Young Vinny and Core.
Thank you. And Daniel?
Hi, my name is Daniel Ornelas. I am the operations manager at SEBA.
And Nick?
Hey everybody, Nick Driver, consultant with Clear Thinking. Nice to see everybody.
All right. And then Mary, we need an approval of the agenda.
Oh, that's right. So we need a motion to approve the agenda. Can I get a motion, please, and a second? I'm sorry, Larry? Was that Larry or Gershom?
That was Larry, and I'll second.
All in favor? Aye.
Aye.
Okay.
And then
I don't
one
have the
more
agenda in
item.
front of me, unfortunately, so I can't
That's
see what's up
fine.
next.
Public comment. So just ask if there's any public.
Okay. So is there any public comment on items not on the agenda? Okay, seeing none, we move on. What's next on the agenda? I don't have it in front of me, unfortunately.
Consideration and approval of Title Holding Limited Liability Corporation.
Okay, so is that where you come in, Josh?
It is.
Okay,
And
the floor is yours.
thank you. And welcome, Michael Jones.
My apologies.
Okay, just make a note that Michael Jones got to this meeting late. No, whatever time it was.
Noted. I got it.
So after deliberation with Young Vinny and Core, our SEBA admin team, and Nick Driver, we have decided to move forward with using an LLC as the vehicle to potentially purchase our school facility. When we were discussing the options, and I think Mary, you correctly asked, well, why don't we just do this through the foundation? After a long discussion, we decided that the articles of incorporation, or excuse me, articles of organization and the formation of this LLC would be the most legally sound way to move forward. And so what you'll see in this agenda item are the articles of organization itself, the operation agreement of SEBA Spartan LLC, that's the name of the limited liability corporation, and then finally the instructions for completing the articles of incorporation that are attached there. I wanted to hand it over to Kimberly to talk about how this LLC will work under SEBA Public Schools and what will be the connection between the SEBA Public Schools 501c3 and the specific SEBA Spartan LLC.
Okay.
Sure. So the LLC will be what's called a single member LLC. And essentially what that means is that SEBA will be the owner of the LLC. And as the owner, its tax exempt status actually benefits the LLC. So the LLC doesn't need to apply for tax exempt status at the federal level to obtain tax exempt status benefits because it's considered a disregarded entity. Because as I said, it benefits from SEBA's tax exempt status. It is a common way to hold title to property. I would say almost every client that I've worked with has held property within an LLC, whether it's attached directly to the school. Some clients have attached the LLC to a supporting foundation as well, just to create a little extra distance, but that's not required. At the state level, one thing to keep in mind is that while it still is exempt from revenue, the state of California does charge an annual $800 fee for LLCs and also charges a sliding scale fee ranging from $0 to I think about $11,000 if you have revenue coming in, and I believe it's like the $5 million range. And to be exempt from that, though, you can apply for tax exempt status as a title holding entity with the state of California. So you wouldn't have to worry about anything at the federal level, just at the state level. In terms of the process, you'll file your articles of organization. There's an attachment with that form document that just really lays out that you're a tax exempt entity so that you can get the benefits of being a tax exempt entity. And so those are filed with the Secretary of State. Those are similar to articles of incorporation for a corporation. And once that's filed, then you'll be a legal entity and can start taking action. You'll also have an operating agreement, which serves essentially as kind of like bylaws for the LLC. The operating agreement really lays out how your organization is structured, if you'll have, who your managers, officers will be, provides basic information like that. And so that document's not filed with anybody. That'll just be kept with your entity. In order to take action, the entity, the LLC, doesn't need to have a board of its own. LLCs don't have boards. Most commonly, they'll have officers. So most of the time, they'll have a president that will be elected to be kind of the day-to-day manager, the person that will sign documents for the LLC when need be. And then SEBA itself will take action as the sole member. It should meet outside of its regular charter school meetings. Meet separately as the sole member of the LLC to take action that needs to be taken with respect to the LLC. I would maintain corporate formalities that way by keeping everything nice and clean and separate, and keeping your LLC record separate from your corporate records of SEBA. But that's the basics. Let me know if you have any questions.
So is there any, so let me just give you the example. If SEBA was to get sued, is the LLC separate from that and they can't attach themselves to the LLC? Is that kind of how it works?
Yeah, I mean, the LLC is intended to be a liability protection vehicle. It's kept separate. The important thing to keep in mind is just making sure you're following all your corporate formalities and treating the entities as separate legal entities. And so, not having commingling funds or having a joint bank account, but making sure that's separate, having your meetings as the sole member to show that it is a separate legal entity. If you kind of give a little bit on the corporate formalities, you could put yourself in a situation where someone says that it's really just a shell entity and it's not really functioning as a separate legal entity. So as long as you're keeping your corporate formalities, that's its purpose, is to isolate liability.
Okay, and one other question. So Josh being head of school, can he be the president of the LLC? Can he be both, right?
I mean, legally, he could.
Okay.
With respect to SB 740 and trying to keep everything separate and distinct, the conflict of interest rules for SB 740 are a little different than your basic statutory conflict of interest rules. And so it actually goes beyond just your board. It looks at key employees and you have to prove up that the key employees had nothing to do with applying for SB 740 funding or entering into a lease agreement. And so it could be a situation, if you do have him as president, where CSFA asks you to kind of prove up to show that there was no involvement on SEBA's side. So really keeping everybody separate and distinct. So you'd have to have a different signatory on SEBA's side and make sure that you have proof or evidence that he was not involved in any of those SB 740 or lease transactions or discussions. So that's kind of what makes it difficult. And CSFA, at least in the past, I've seen them kind of dig a little bit and even go as far as searching on the Secretary of State website and finding the agent for service of process title and realizing that that's a key employee at the charter school level, and then asking a bunch of questions about this person's role and involvement. And agent for service of process, it's not like an officer position. There's no, authority there to act as an officer, but CSFA doesn't care and still required a bunch of background information. So it could create more work for you to kind of prove up that there was no conflict of interest under SB 740 rules. So that's why some clients will stray away from keeping like a key employee, or definitely not like a board member in that role.
Right. Okay, I was going to say, after that explanation, Kim, maybe we shouldn't. So, okay. Thank
Great
you.
But
questions,
do we
Mary.
need to have a president of the LLC?
You don't, you're not required to have officers either. I would say most of our clients probably do elect a president just because it's easier to have a point person, someone that can, essentially be the manager or, take day-to-day action as needed.
Makes
I've had some clients that kind of in the beginning, they couldn't figure out who was going to serve in that capacity. And so they actually had someone, an officer at the charter school level sign, but it was always as their title position as the like secretary, for instance, of the sole member. So on all the documents, your signature line is really long just to explain who you are and your position, that you're not an officer of the LLC or an officer of the sole member. But that can be done. I've had a few clients recently that have done that instead of actually electing someone because they couldn't figure out who would fill that role right now.
Mm.
So do you have any examples of people that fill that position in other situations? Because you're saying they're not supposed to be an employee of the school and they're not supposed to be a board member. So
Yeah, we've had
who you
lower
find?
level employees. I think when you're SB 740 rules look at key employees, so like your higher level administrators. I've sometimes have had clients that have chosen a lower level, like an assistant or somebody to serve in that capacity. If you had somebody that was like a former board member of your school, no longer a board member, somebody that still wanted connection and to assist the school and serve in that role, they could also serve in that role, as long as they're not a current board member. So I've seen that.
Okay. Yeah,
Is
that's what they do.
is that why Daniel's in the center of my screen tonight?
Hollywood Squares.
Yeah. So that was supposed to be an attempt at being funny, but would Daniel be an appropriate person for that kind of position?
I think he could. I mean, I would just make sure, like in his position, that he would not typically be involved with SB 740 decisions or
Oh.
lease operations. Yeah, if he's somebody
Yeah.
that's integral to that, then you're
Never
going to
mind.
have to show that, yeah, he was not
Yes.
involved in any way. So picking somebody that's kind of not kind of outside of that like scope would be beneficial. And not saying again that it's prohibited, but you would just have to prove up. So you're going to have to
Yeah.
possibly show more information to prove that he was not involved.
Mhm.
Josh, have you already come up with a solution for this?
No, we had this conversation on Friday and great questions, Mary. And I was thinking just like you, Michael, I was thinking Daniel, and then
What about Dina Hoffman or something previous, right? Dina, she might be.
He's a lawyer.
I talk occasionally with Tom Brown even. Maybe I can send
Oh,
it to-
yeah. Mm-hmm.
I'm happy to serve, but I think it might be behoove the school to have somebody at the school level who works at the school. Perhaps Rachel would be a pick, who's not directly into the decision-making process for this and who works on a daily level with you, Josh.
Is there any additional benefit in terms of liability, Kimberly, to have somebody who is just not an employee of the school versus a lower level or employee of the school who's not directly involved with SB 740?
I mean, I don't think it's really a liability question. It's more of just the more distance and the more distance you can show, or the cleaner it is, the less work you might have to do down the road in proving things up. Like if it's somebody that's completely unattached to the charter school entity, then you'll have less work because there won't be anything to show that there's some sort of connection or that person being on both sides of the transaction. So it would make it easier. But again, it's not required. And many times, the person that is chosen as the president is somebody that has some sort of attachment to the school because they have an interest in, benefiting the school in that way.
Is there any rules around geography? Like you have to live in the state of California or in the county?
No, not especially LLCs, like they're far off from all the
Yeah.
regulations that the corporate form would have. So you have more flexibility there.
Definitely.
If we were to go to someone who's not an employee of the school, someone like a Tom Brown or a Dina Hoffman, what liability are they subject to by filling such a position?
They're not acting in their personal capacity. I mean, if there was some issue with like, obviously like their own personal liability because if something was fraudulent or something like that. But if they're acting on behalf of the LLC, they just have a title. And when they sign documents, they're signing as president of the LLC. So they're not acting in their personal capacity. So they're not subject to personal liability.
Let me put out just it's a terrible example, and I apologize for it. But let's say we go through this, we have the LLC in place, we own the building. Say Tom Brown is the president, and the building collapses, and 100 students are killed. The lawsuits start coming. Could that person in that position be sued?
I think anybody could be sued. The school, for instance, could be brought in, obviously, and they'd look for deep pockets probably if they're suing with that type of, with that type of liability that you're talking about. But, but when they would get to court, they would say, I'm an officer. I'm not acting in my personal capacity. I was acting within the scope of my duties and responsibilities. And so there would not be that personal liability, even if they were included in a lawsuit. A lot of times we have board members that are sued in lawsuits, and that's how they get out as well, is they were acting in their professional capacity as, a director or an officer. So it's the same situation there with the LLC, where it's not their personal, they're not personally taking action. They're only acting because the LLC is an entity that can act for itself. So they're an officer.
And they would be an officer of the, under the directors and officers insurance
Right,
that
Dina.
school has with Charter Safe, they would be covered under that.
I would definitely check with the carrier and make sure you let them know that we have a policy. Now we're going to have this LLC in place. We want to make sure that that officer is covered as well. And I don't know if they may require the LLC to get its own policy because it is a separate legal entity, or if they'd be able to put you under for the charter school. But that's a great question to bring up with the insurance carrier to make sure.
Mm-hmm. Makes sense.
When do we have to resolve this question?
2 months.
Yeah,
Does-
I think it's based on your transactions, whatever you have coming up when you need somebody to sign a document. I'm not sure.
But I mean, our work tonight is to approve these documents regarding the LLC. So we don't have to make that decision when we approve these.
No, and really what you're going to be doing if you approve it tonight would be approving of the filing of the articles of organization. You won't even be able to approve the operating agreement because the entity is not going to be in existence yet. And there's information you're going to fill in once the filing date and things like that, essentially ratifying the filing. So that piece doesn't even have to be approved tonight. Typically, once the articles of organization are formed, you would have a meeting as the sole member, and you would take the action that you needed to take, including approving of the operating agreement, electing officers if you wanted to. Again, that's not something you even have to do then. It just really depends on your timeline for taking action. When do you need someone signing for you on the ground floor? That will kind of be the determining factor. But as I mentioned, even then I've had clients where they've needed, like for a bond transaction, to have someone sign, and they've ended up just using someone on the corporate end, but being very clear in their signature line that they're signing as secretary of the sole member. So you could potentially even stretch it out past that if you're still not ready to put someone in place as the president.
Okay.
I think the questions here, the phrase that comes to mind is piercing the corporate veil, correct, Kimberly? And it's when things are not done properly. Maybe there's not accurate record keeping. Maybe there's some type of fraud that happens. And if that were to happen, then somebody could become personally liable for the whatever transpired. Is that an accurate statement, Kimberly?
Yeah, I mean, I think that piercing the corporate veil will typically come into play, like in terms of personal, like individual liability would be if the LLC was owned by that person. Like if that was that person's LLC and they were not properly following corporate formalities. Here, piercing the corporate veil would come into play with your charter school entity with SEBA. If they found that SEBA was just using this as a shell entity and it really wasn't keeping the separation and the distance and the corporate formalities up. But that wouldn't result in the personal liability of your officer. What could result in personal liability is if they're taking their own action, as you mentioned, fraud, doing something, above and beyond their scope of duties, then that's when obviously they have their own liability. It's not even the LLC's liability.
Okay, I'm gonna have to run to my next meeting, so I don't know if you want to take a vote, if that's what we're looking for, or if
Yes.
I can step away and you still have you have a quorum. So just so you know, Josh.
Thank you, Mary.
You bet.
Well, as long as you're still here, Mary, does anybody else have any questions for Josh, the lawyer, about this? Is there a motion to approve 2A1 articles of incorporation, since that's what I think is you're saying the only thing we can vote on tonight?
So moved. Mary.
Okay, we got a motion. Do we have a second?
I'll second.
Larry seconded. Mary, how do you vote?
Aye.
Larry, how do you vote?
Aye.
Gershon, how do you vote?
Aye.
And Michael Jones votes aye as well. So the motion is passed.
Okay. Thank you, guys.
Thank you, Mary.
I'll see you later. Bye.
Bye, Mary.
Bye. Take care, you guys.
Bye.
So the operation of agreement is something we'll deal with at a later meeting.
Yeah, once the articles of organization are filed, you can have your first meeting as the sole member, and that will be part one of your action items.
Alrighty.
All right, I think that's it then, Kimberly, in terms of we just need you here for item A. So appreciate you
Okay.
taking the time.
Sure, no problem. And
Thank
let me
you.
know if any questions pop up as you're moving along.
Thanks, Kimberly.
Good night.
Good night.
Thank you. Good night.
So now we're moving on to the discussion items and the comparison of leasing versus buying.
So this came up, I think, from Mary, but this is basically why we're doing this. So you can just look at it. SB 740 facility grant, if it's funded at 100% levels, we'll save 1.5 million just in payments, let alone the equity over the 35 years of this bond term, for a total savings of 9.5. And as you go down this document, you can see the SB, like there was a concern about SB 740 grant funding being less than fully funded. So at the next level, it's at 75%. And here we see that there's still $1.2 million in just payment savings, cash flow savings, let alone the equity. As you go further down, we see if it's funded at 50%, we still see a savings over the 35 years of $901,000.
And when we get to 0%,
0%, we would have a savings of $500,000 plus the building equity.
we're still saving money.
Correct.
This sounds to me like a no-brainer.
Totally.
That was my thought, Joe. All right. Well, I'm glad we're in agreement.
All right.
Agreed.
Anything else needed that we're going to cover tonight?
No, if I could just say, I'm going to be reaching out to each of you individually over the next couple of days. Prior to you joining, Michael, I wanted to go through the reopening plan with everyone in an open format. And so we sent out surveys to families and also sent out surveys to teachers. And now I think we need to find a solution to what the opening plan will look like for Save Q4. So I'm going to seek your input individually over the next few days here.
Okay. Sounds exciting. Okay, hearing no further business, I have a motion to adjourn.
I'll motion.
Second? Go ahead, Larry. Oh, no, I'll do it this time. I'll second. All those in favor, Larry,
Aye.
Gershom,
Aye.
and Michael votes aye as well. Meeting adjourned.
Thanks, everybody.
Thank you.
Great.
Thank you.
Thanks,
you.
everybody.
Good night.
See you
Good
next
night.
Good night.
Yeah.
Adios.